I am Steve Ratner. I am a law professor, but more importantly, I'm the director of the Donor Human Rights Center, and I'm delighted to welcome all of you to our third monthly event for this academic year on the subject of human right to a healthy environment. I just would like to introduce our presenter, who is Jennifer Haverkamp. Jennifer is a professor for practice at the law school and at the Ford School. And she is also the director of our University of Michigan Graham Sustainability Institute. Jennifer will be introducing our speaker, serving as commentator, and also managing the queue of questions from in the room and from Zoom. You'll be getting instructions for those of you listening virtually or tuning in virtually about how to get your questions to us. And I look forward to a lively discussion. Jennifer?
Good afternoon, everyone, and it's my great pleasure to join Steve Ratner in welcoming you to this event. Given the title, Human Rights and the Environment, I challenge anyone to come up with a better person to speak on this topic than our guest today, John Knox. John has a long history in this area, and many people think that we would not be anywhere near to a UN Council resolution on adopting a human right for the environment without John. And I would also say, as someone who's worked a long time in the international field, where progress is very slow and incremental, it looks like you did this a lightning speed too.
It doesn't feel like that.
I'm sure it didn't feel like it at the time, but it's still impressive. So our speaker, where does he come with this expertise? Well, from 2012 to 2015, he served as the first United Nations independent expert, and from 2015 to 2018 as its special rapporteur, its first special rapporteur on the issue of human rights obligations related to the enjoyment of a safe, clean, healthy, and sustainable environment. And through that work, by 2018, he concluded his mandate in that job by presenting framework principles on human rights and the environment to the United Nations, and by calling on the General Assembly to recognize the human right to a healthy and sustainable environment. And you will hear from him what happened just a month ago. A little more of his background. I'm condensing this, believe me. In 2003, he was awarded the Francis Deep Prize, which is a prize given by the American Society of International Law to honor a younger author who's made a meritorious contribution to international legal scholarship. He's currently on the board of the Universal Rights Group, a human rights institution in Geneva. And he served as an attorney advisor at the Department of State from 1988 to 1994. This was after graduating from Stanford Law School and clerking for Judge Joseph Sneed on the Ninth Circuit in San Francisco. And I would also just add a personal note, which is back when he was at the State Department. This will date us both. In 1993, we worked together when I was at the Office of the U.S. Trade Representative, negotiating the environmental side agreement to the North American Free Trade Agreement. So it's just wonderful to have you here on campus, and we all look forward to what you have to say.
Great, thank you so much, Jennifer and Steve. It's really a pleasure to be here with both of you. As Jennifer says, she and I go back now nearly 30 years. Steve and I go back even farther. When I was an intern at the State Department back in 1987, Steve was what you had just started a year or two earlier, and so helped to kind of show me around. We used to go out to lunch and talk about what we would, how we would change international law if we had a chance. And look at us, we're not here. All right, so let me start talking about human rights and the environment a little bit. The basic starting point to understand the relationship of human rights and the environment is that the two fields are interdependent. That is, as this slide says, a healthy environment is necessary for the full enjoyment of a wide range of human rights, including rights to life and health, but also the exercise of human rights is necessary to be able to fully protect the environment. One way of expressing this relationship is simply through recognizing a human right to a healthy environment. But another way that I'm going to spend some time talking about is through what I've called greening human rights, that is, applying other human rights, rights to life, health, and so forth, to environmental issues and seeing what obligations states have. This first path, the path of recognition of a human right, you would think an obvious place to include a human right to a healthy environment at the international level is in the Universal Declaration of Human Rights, which here we see Eleanor Roosevelt, the chairperson of the Human Rights Commission that drafted the Universal Declaration that was adopted in 1948. The problem, of course, is that the modern environmental movement really didn't take off until 20 years later, and so it kind of missed the boat to get it included in the in the Universal Declaration. However, that excuse doesn't really hold water for why it's not included in subsequent UN global human rights treaties, which it also is not. That is, the 2 international covenants on human rights don't include a right to a healthy environment. Neither does any other global international human rights treaty. At the same time, there's this kind of gap at the UN level, at the local level, at the national and regional level. The right to a healthy environment was being recognized by most of the countries in the world. Something like on the order of 100 countries in the world now explicitly include a right to a healthy environment in their national constitutions. Not all of them refer to the term healthy, some use other things like sustainable or satisfactory or so forth, but the idea there is that this is a standard part of the constitutional set of rights for at least half the countries in the world. But even this really understates the number of countries because a number of other countries belong to regional treaties in Africa, the Americas, Southeast Asia. There's a human rights declaration that Southeastern Asian countries belong to. All of these instruments recognize some form of a right to a healthy environment. So when you add all these countries together, and when you throw in the countries that have interpreted through judicial decision their constitutions to have an implied right to a healthy environment, countries like India and Pakistan, you get most of the countries in the world. My successor as the Special Rapporteur, David Boyd, is estimated, or not estimated, is calculated that 155 countries in the world, one way or the other, now recognize a right to a healthy environment. Now, the United States is not among those countries, although some states in the United States recognize the right to a healthy environment. Most recently, New York State, just last week, or I guess maybe the week before last, ratified an amendment to the New York State Constitution through a popular vote on election day that now adds a right to a healthy environment to the New York State Constitution. They joined about 5 or 6 other states in the United States that have done the same. But in the absence at the United Nations level or the global level of a right to a healthy environment, instead what we have seen for the last 20 or 25 years is that many human rights bodies have interpreted existing human rights, rights to life, health, and others, to give rise to duties on states to protect the environment in order to be able to safeguard those human rights. So these are pictures of, for example, the European Court of Human Rights, the Inter-American Court of Human Rights, and a number of special rapporteurs, that is, human rights experts appointed by the Human Rights Council to promote and monitor compliance with specific human rights or human rights with respect to specific areas. So what did these bodies end up doing? What they ended up doing was saying that environmental harm interferes with the enjoyment of a huge range of human rights, rights to life, rights to private and family life, rights to health, rights to non-discrimination, rights of indigenous peoples, and so forth. And so over time, they created a kind of environmental and human rights law jurisprudence. Now, the problem with this is because there were so many different bodies that were interpreting so many different agreements to come up with this jurisprudence, it wasn't totally clear what it all added up to. And on top of that, the Human Rights Council, the main United Nations human rights body, the body that had in fact replaced the Human Rights Commission that Eleanor Roosevelt chaired, the Human Rights Council wasn't all that involved in any of this anyway, because again, without a right to a healthy environment to kind of tie it all together, it wasn't really clear what the council's, let's say, foothold was here. So in 2012, the Human Rights Council decided to appoint for the first time an independent expert, essentially to try and clarify what this relationship of human rights and the environment amounted to. As Jennifer said, I had the honor of being appointed to that position. By the way, for those of you who have never been, this is the council meeting room in Geneva, the Palais des Nations. That ceiling is not an accident. It's not like it was being, prepared or something. This is how it looks. It's actually a quite interesting piece of art by a Spanish artist. It does look at times like parts of the ceiling are going to fall in. I think that maybe have been intentional, but it actually really grew on me over time. I came to really love the ceiling. Anyway, so in 2012, the council appointed a new mandate. As I said, the council often appoints special rapporteurs to promote compliance with human rights. But occasionally the council says, okay, so this area isn't really clear enough to promote compliance with it, to appoint someone whose job it is to promote compliance with it. So instead, we're going to appoint someone to essentially clarify the relationship of human rights and the environment. So I was appointed to clarify this relationship. And you see how they wrote the resolution: to study the human rights obligations relating to the enjoyment of a safe, clean, healthy, and sustainable environment, and to identify, promote, and exchange views on best practices. So this is a 3-year mandate, and I spent most of the first 2 years undergoing what I called a mapping project. Essentially, I wanted to see exactly what this body of environmental human rights jurisprudence amounted to. So with the help of a lot of volunteers, human rights lawyers, academics, a lot of people working pro bono, we issued a series of 14 reports, each of which examined one particular treaty or source of human rights jurisprudence. And we issued these reports, some of which were as long as 80 or 90 pages. And essentially, each of the reports examined exactly what that body or that source, that set of sources had to say about the environment. I also held a series of consultations, regional consultations in lots of different places around the world to see what people on the ground actually were doing and saying about the relationship between human rights and the environment. And this culminated in a mapping report that I presented to the Human Rights Council in 2014, where I said, actually, there's a huge amount of consensus, despite the fact that all these bodies are interpreting different agreements and they're in some cases interpreting different rights. They actually agree about a lot of things. In particular, they agree that states have procedural obligations in relation to this duty to protect against environmental harm to human rights. The procedural obligations include things like providing environmental information, facilitating public participation in environmental decision-making, and providing effective remedies. Substantively, states have more discretion. No one expects Ghana, for example, to have exactly the same environmental standards as Germany or Denmark. However, that's not to say that the discretion is completely unbounded. They should adopt and implement environmental standards based on the precautionary principle, based on international standards that may apply, such as those adopted by the World Health Organization. And then once they adopt them, they have to implement them, including against private actors. And overarching all of this, they have obligations not to discriminate and to ensure that they're taking into account those who are most at risk of environmental harm. So in March 2015, the Human Rights Council said, okay, basically now, I'm going to paraphrase here a little bit, but they said basically, okay, you've clarified the law well enough that now we think we can change your title to Special Rapporteur. And ask you to start promoting and reporting on the realization, that is the compliance with these human rights obligations, and to work on identifying challenges and obstacles, which I, under special rapporteurs, would interpret to mean like violations. The Human Rights Council, the governments on the Human Rights Council hate to use words like violations. They don't like to be seen as criticizing each other that much, but special rapporteurs can do that. So that's what I spent the next 3 years doing. I continued to issue reports that tried to clarify the norms in particular areas, but I also took steps to try and promote the implementation of the norms that were already recognized. That meant I did things like go on country visits to different countries and receive communications from individuals alleging violations and so forth. I want to say just a word about 2 particular areas I worked on, that is with respect to environmental human rights defenders and with respect to framework principles on human rights and the environment. Every trip I went on, every consultation I undertook, whatever we were planning to talk about, we ended up spending quite a bit of time talking about the threats that environmentalists in those countries were facing. I had known something about this before I took on the position, but I was still shocked about how much larger the threats to environmental defenders were than I had realized everywhere in the world. In 2014, an organization called Global Witness issued a report that went back over the previous 12 years, back to 2002, and tried to just simply identify how many environmental defenders have been killed because of their work over that period of time. And what they found was truly shocking, I think, because so often these cases weren't really reported often in the media. They found 908 cases of environmental defenders being killed over this period of time. Now, to be clear, this is not an area of human rights law where there's any doubt. States have obligations. This was not an area, in other words, in which clarification of the state's obligations was necessary. States have obligations to protect environmental defenders like other human rights defenders. When they're subject to threats, they have obligations not to restrict their work and to investigate threats and harms against them. But states obviously were failing to do this. In fact, Global Witness found that of these 908 cases, 6 had resulted in some kind of prosecution. So in many of these cases, there was simply impunity. This is a global problem, but it's especially acute, they found, in Latin America and Southeast Asia. But they also, again, I'm just describing the Global Witness report here, they also emphasized that for much of Africa in particular, they simply did not have enough information to know. So when you see these clear places in the map, you shouldn't assume that means, oh, everything's great there. It just means there's not enough of reporting for them to be able to know what's happening. Since then, they have issued an annual report every year that updates this for the previous year. For example, between 2015 and 2017, again, they're describing human rights killings of human rights defenders across the Global South. 2019, they identified 212 killings. Other human rights organizations as well have work with human rights defenders have also verified this from this perspective. A frontline defenders report that works with all kinds of human rights defenders and counts killings of all of them said that of the 331 killings of all types of human rights defenders last year in 2020, 2/3 of them were of environmental defenders. They are the most at-risk people in the world. Of those defenders, a disproportionate percentage are from Indigenous peoples who are more likely to be in vulnerable situations, more likely to be marginalized, and in places where the resources are considered valuable. And so therefore their ability to protect their attempts to protect their land from assault put them even more at risk. Examples, just because I hate to go through all this as if these are all just numbers when there are people. Each one of these killings, obviously there's a person, there's a life, there's a family and a community at stake. To give a couple of examples, Berta Cáceres in Honduras was an indigenous leader who had fought for many years to protect her people from displacement as a result of a massive hydroelectric project in Honduras. She had received death threats for years. She was extremely well known. She had received the Goldman Prize. In fact, she was the current Goldman Prize winner for Latin America. The Goldman Prize is an award given by the Goldman Foundation to people in different regions of the world. Essentially, it's kind of like a Nobel Prize for grassroots environmentalists. So she had met with human rights special rapporteurs, for example. None of that saved her from being assassinated. I also want to emphasize that not everyone, that the focus on killings, as important as that is, should not obscure the fact that many environmentalists are harassed, detained, beaten up, threatened in all kinds of ways, short of being killed. An example here is this Vietnamese woman known colloquially as Mother Mushroom, because that was her blogging name. She blogged about environmental problems, and including a massive toxic spill off the coast of Vietnam that resulted in adverse consequences for fishing communities along the coast. She simply wrote about it on her blog. For that, she was arrested by the Vietnamese government, accused of crimes against the state, and in 2016 sentenced to 10 years in prison. Because of international outcry, she was basically she was released after 2 years on the condition that she leave the country, and she's now living in exile. All right, so that covers something about environmental defenders. Just to go back to my mandate for a moment, I finished my mandate by presenting framework principles on human rights and the environment that just tried to sum up what all of these human rights obligations amounted to. And I did that in 2018. The Human Rights Council, that concluded my second term of my mandate. It can only serve 6 years, which is a good thing. It's kind of tiring. And then that concluded my second term, and the council said, okay, we're going to continue the mandate, and now we're going to ask the new special rapporteur to report to the General Assembly as well. The new special rapporteur, David Boyd, has issued a number of reports since then. He's been extremely active, and a lot has been happening in this field. I could go on for a long time just describing all the things that have happened in the last 3 years in this field. For example, these people are celebrating the conclusion of a new agreement in Latin America and the Caribbean called the Escazú Agreement that essentially sets out detailed requirements on states with respect to rights to environmental information, participation, and remedy. A Human Rights Committee that oversees the International Covenant on Civil and Political Rights has issued reports. Its first one on the environment came in August 2019, in which it held that Paraguay had violated people's rights to life by not adequately protecting against agrochemicals that had resulted in the death of a local person. A member of the Human Rights Committee said hundreds of similar cases around the world could be submitted for our consideration. We deeply encourage states to protect their right to life, understood as the right to enjoy a life with dignity against environmental pollution. It's another example of how, even without a formal right to a healthy environment, human rights bodies are increasingly reading human rights to provide that level of protection. At the domestic level, the most important climate case yet decided was decided in December of 2019 on the basis of international human rights law as implemented by the Netherlands. The Dutch Supreme Court held that the Netherlands had not moved quickly enough to reduce its greenhouse gas emissions, and as a result was violating the human rights of its people. That is, the rights protected by the European Convention on Human Rights. I could go on, I'll just give you a couple more. The first case involving so-called climate refugees was decided last year by the Human Rights Committee on a case involving someone who was a native of Kiribati who was hoping not to be sent back there because of the effect of climate change. The committee said, we don't think the effects are bad enough now, but they are heading in a direction that we will start to decide this kind of case, to prevent the refoulement, the return of people against their will to countries most at risk from climate change. Just last month, the Committee on the Rights of the Child, which interprets the Convention on the Rights of the Child, issued their first climate decision in a case brought by Greta Thunberg and 14 other children and youth. They actually decided that they weren't going forward with the case because of a failure to exhaust local remedies, but they included a lot of strong language that again paves the way for future cases like this. One case that's pending right now at the Human Rights Committee is a case against Australia that should really come out hopefully before the end of the year, arguing that Australia has not done enough to protect people in the Torres Strait Islands from the effect of climate change. There are dozens more cases like this pending. Human rights has turned out to be an enormously powerful basis for litigation, environmental litigation, and climate litigation in particular. So all that brings me to the title of the talk. Why have a human right to a healthy environment? What would that add to all of this? What I've just described is this enormously productive, blossoming area of the law. What would recognition of a human right to a healthy environment add? This is my successor, David Boyd, a professor at the University of British Columbia. In my last report, which overlapped with his first one, so we filed them jointly, we called on the General Assembly to adopt a human right to a healthy environment for the first time. What were our arguments? Why do that? What does that add? I think there are three things in particular I'd like to emphasize. One is it elevates the importance of environmental protection. Having a formal United Nations recognition of the right to the human right to a healthy environment says that it's the same level of importance as other rights that we've said are fundamental to human dignity, human freedom, human equality. It means that you don't have to simply kind of construct this human right to a healthy environment from all of the different human rights I've just spent 20 or 25 minutes describing. People understand when you say there's a human right to a healthy environment. That's simpler, it's punchier, that matters. That matters. It also serves to integrate human rights law on the environment. That is, it brings together under one umbrella this idea that there's this burgeoning body of environmental human rights law, or environmental human rights jurisprudence. And in particular, it says that environmental harm itself is a human rights violation. So you don't have to always make the connection in every case between environmental harm and the effect on some particular aspect of human life, like the right to life or the right to health or so forth. You can simply say that because of harm to the environment, we can take it as given that these other effects are happening. And then finally, most practically, it provides a basis for further action. At the international level, having a right to a healthy environment means that certain other types of international human rights mechanisms kind of leap into existence or take better effect. Things like the Human Rights Council system of universal periodic review, under which it reviews the human rights compliance record of every state in the United Nations. They already talked about environmental issues somewhat there. This would make it much easier for them to do so. At the domestic level, where this is really going to happen or not, it will push states that don't have the right to adopt it, we hope, and states that have the right and have adopted it but don't really implement it, it will push them to do a better job as well. There's we discussed different ways of kind of recognizing this. You can imagine it happening through a standalone treaty. The French government suggested such a treaty in 2017 without much success, unfortunately. It could be a protocol to an existing treaty. The Europeans are currently considering a protocol that would add this right to the European Convention of Human Rights. And then what David, Boyd, and I thought would be the simplest approach, simply adopt a new United Nations declaration or resolution. And guess what? That's what finally happened. The last session of the Human Rights Council in September, which just ended October 8th, so a little over a month ago, the Human Rights Council considered for the first time the proposal to actually adopt a human right to a healthy environment. This is the so-called zero draft, which is what diplomats in Geneva call the first draft of the resolution before it's been amended at all or formally introduced. I had some input into this draft just between us and all the people watching at home. But it was simply based on, it's not like my own creativity came into this at all. It's simply based on David and I provided advice that it would be best to base this on an earlier UN resolution that adopted the rights to water and sanitation in 2010. So like that earlier resolution, this would simply recognize the right to a safe, clean, healthy, and sustainable environment as a human right and affirm that the right is inextricably related to the right to life and other human rights. We thought that would be good. However, this is what finally came out as a result of the negotiating process. Some words were dropped, others were changed, but the core remained there. That is recognition of the right to a clean, healthy, and sustainable environment as a human right. That's the key language. Note that safe got dropped there. We can talk about why that happened a little bit if you like later. There's also the interesting addition in paragraph 3 of the statement that the promotion of the human right requires the full implementation of multilateral environmental agreements. In other words, to comply with this right, you really should be complying with the multilateral environmental agreements that you're a party to. This is a picture of the Costa Rican ambassador while she's introducing the right. This right was carried forward at the Human Rights Council by Costa Rica in the lead, but a number of other core governments kind of supporting them, including Slovenia, Morocco, Switzerland, and the Maldives. I have to say it was a bit nerve-wracking, this process. A lot of countries, those countries that I just mentioned are all extremely well respected, but none of them are big, powerful states of the type that when they say this is what we're in favor of, other states just kind of line up because of who they are. They have to win arguments based on the merits of the argument rather than just because they're powerful states that can command allegiance in that respect. So as late as the week of the vote, there were still a lot of states. Of the 47 states on the Human Rights Council, probably about half of them were still on the fence. This is what the final vote looked like on Friday, the last day of the Human Rights Council session. It was adopted by a vote of 43 in favor, 4 abstentions, and none against. And I have to say, this is a huge triumph for the diplomats that worked on this.
For you. You should take a bow, John.
I was sitting in North Carolina watching this on UN TV, really underlooked streaming service. You're not already subscribed, but there were some last minute kind of developments here. Russia in particular have been very much opposed to this. They introduced something like 10 amendments, each of which had to be separately voted down. It wasn't until after those amendments were all voted on and voted down that Russia called for a formal vote on the resolution. The way the UN works is if there's no country calls for a vote, it simply is adopted by consensus. We knew that wasn't going to happen. We knew someone would call for a vote. When Russia called for a vote, we were like, okay, here we go. We knew it would pass. That wasn't the issue. But for something like this, it has to pass overwhelmingly, or you have something that's like, well, who really believes in this as a human right if 51% of the countries are all that supported it? So when Russia called for a vote, we were braced for what it would say next. But what it actually said next was, we're going to call for a vote, but we're not going to vote that. That was a huge signal because they had been the country that was most opposed. And by saying that they didn't oppose it so strongly that they would vote against, that meant that probably no other countries would as well. The only other 3 countries that abstained were China, India, and Japan, none of which have it in their own constitutions. And so I don't think they have the same familiarity with it that many other countries do. The other big surprise at the end was the United Kingdom. The United Kingdom had been very much, let's say, in I don't want to say strong opposition, but had been very doubtful, skeptical about the utility of this. It wasn't until the morning of the vote, really for most of us, it wasn't until they actually announced their vote that we knew for certain that they weren't going to abstain, at least. So when the UK said, you know, we still have lots of questions about this, we're not really convinced this is a good idea, but we also don't want to break with the big majority here, so we're going to vote for as well. That was a really big moment. This is my successor, David Boyd, who's right after the vote posted this on Twitter. Very happy guy. He also posted, I immediately put my mask back on, just so you all know. This is me in North Carolina. I got the call from, I'd obviously watched this that morning, but when I was teaching my class later that day, David and the ambassador, the Costa Rican ambassador, called me, and one of my students had the presence of mind. I see that I'm actually wearing the same tie. I have more than, just so you know, I have 3, 4 at least. But anyway, one of my students had the presence of mind to take this call, which I took in class, from David and Catalina, basically just having a moment of celebration, which was pretty awesome. And we were very, very happy that day. Remarkably, the Human Rights Council wasn't done. Later that day, it adopted another resolution, which created a new special mandate for, creating for the first time a mandate on climate change, appointing a special rapporteur on climate change and human rights. And that was a very similar vote, although Russia did vote no on this one. That's all I have to say about this. This is my, all I pretty much do on Twitter is post about human rights and the environment. If you're interested in that, then you're welcome to follow me on Twitter if you want to hear more about this kind of stuff. But otherwise, I'm happy to talk and take any questions you might have now, and I'll hand it back over to Jennifer.
Well, that was really wonderful. Thank you. I am mainly here to moderate a discussion that we have with all of you. Unlike John, I am not an expert in human rights, and so I'm not going to take the usual commentator role of, well, but did you do that? I think we got that wrong. So that's not my role today. I do want to kick off with a couple questions or observations myself, and then open it to the audience, and I'll be taking your questions both through the Q&A for those of you online. Those of you here in the room, I'm happy just to call on you if you raise your hand. When I call on folks, that would be, you're willing to say your name so Professor Knox knows who's talking to. So I have 2, I guess, main kickoff questions. The first one is, what difference does this really make? And I ask that because when you showed the map of all the countries that had this adopted, Russia was one of the countries colored in. And then you say that Russia, was the big opponent to making this a right at the UN level. I also saw Brazil on the list of countries that voted yes, and they struck me as the country that was killing the most people in their own home country. So how do you see doing this at the UN level really making a difference for those countries where we want to see the human right to a clean and healthy environment being respected on the ground?
Yeah, so that's a really good question, obviously. That's a question you could ask about a lot of human rights, right? It's really easy to write in your constitution or into an international treaty a really great list of human rights, but what difference does it make if you don't comply with them? I mean, so to take a couple of your examples, certainly in countries like Russia and Brazil, there's no particular correlation, let's say, between having a human right to a healthy environment in those countries and having a lot of protection for environmental defenders and necessarily having stronger environmental protections. However, a lot of people have actually done studies on at the national constitutional level of the countries that have a right to a healthy environment and have concluded that there is a correlation between across the board. Again, there are exceptions, but across the board, countries that have the right to a healthy environment in their constitutions do tend to have stronger environmental protections. Now, there's various reasons why this might happen. One reason might, of course, be that it's correlation without causation. You know, the countries that are more interested in protecting the environment, this is simply one of the ways they express that. It's also true that for lots of countries, having a right to a healthy environment provides a basis for enforcement that doesn't otherwise exist. Again, not true of every country, but for many countries, this is not a dead letter. This is the basis for an active civil society to bring lots of cases that actually the courts and judiciary end up enforcing that make a real difference. In other words, it can spur better environmental regulation. It can fill in gaps in environmental regulation. It's more than simply a symbol. Now, again, other things have to be true for that to happen. You have to have an active civil society. You have to have a judicial system that is willing to hear those cases and make decisions based on them. But there's nothing different about a right to a healthy environment in that respect than I would say the vast majority of other human rights. This is the question of compliance with and implementation of human rights is a challenge for all human rights. There's nothing unique or uniquely difficult about the human right to a healthy environment.
Fair. Then another thing I noticed in the presentation was, again on that map, two of the countries that weren't colored in, that don't have it domestically, were the United States and Canada.
Mm-hmm.
Yet our special rapporteurs were you from the United States and now David Boyd from Canada. So I just thought that was a little interesting.
You're saying we're not doing a very good job. Our own countries, we can't get anything going with that.
That's your next challenge. We'll come
Yeah,
back in 5 years and you'll tell us how you did every year in the US. No, that's great. Just one other question before I open it to the audience was, you mentioned at the end there that they've moved on and created this new special rapporteur related to climate change. And how, having served as a special rapporteur, is that something you welcome, or how will you distinguish between that person's job and David Boyd's job?
Right. That was a question that that I actually got asked in over the last year. Some of the people who had questions about this new rapporteurship were like, well, isn't this already covered by this other mandate? What would this really add? All I can say is when you have the mandate of human rights in the environment, if you think about it, that touches pretty much everything. Like what isn't included in a mandate that's called human rights in the environment? What's left out? And so a big challenge in that mandate is figuring out what to prioritize and what to concentrate on. So yeah, I could talk about climate change. In 6 years, I issued one report specifically on climate change because now I did a lot of other things on climate change as well. But that, as important as that is, that's only one aspect of all the full range of things that's in the scope of my mandate. So climate change is such a pervasive issue. In many ways, it extends far beyond just environmental issues to include issues of energy use and transition, labor rights, and just our entire economic system is kind of bound up with climate change. So I was very much in support of having a rapporteur that just would focus on that. How David wants to work with that rapporteur, I think there's some area of overlap, certainly, but either David can find ways of supporting that, or David can just simply say, great, you focus on climate change, I will focus on the other, everything else, which still gives me lots of things to do.
And will that progression lead to a progression where we then are aiming for a UN human right to a safe climate?
My view on that is that once you have the human right to a healthy environment, you don't really need to continue to kind of subdivide it formally. That is, that encompasses all of the different ways in which an environment needs to be healthy, including one that's, essentially a climate stable environment. So I don't personally see that as necessary any more than you would need to be clear that the right to life means the right, not to be arbitrarily killed by your government in this way, and also not to be arbitrarily killed by your government in some other way, if that makes sense.
Okay, very good, very good. All right, anyone here in the room have a question? Start us off. Yes, please.
Hi, my name is Christian. This was really great, really inspiring. I'm thinking in terms of at the UN level, what's the next sort of piece of, what's the next step that you hope will come after this now?
That's a great question, because I meant to get to this and didn't, so thank you. So the Human Rights Council, as important as it is not the General Assembly. The General Assembly is the usual body that is considered to speak on behalf of the international community as a whole. So our idea was always that the Council, as a subsidiary body of the General Assembly, would act first, but then the General Assembly would act. And we're hopeful that that will happen as soon as this year, at least this General Assembly year, let's say, which this session, which may well be after December. I don't expect that it will get adopted as soon as this December, but I do expect that as soon as December, the process will start. By that, I mean, I'm hopeful that as soon as the first week or two in December, we'll have a launch of some kind where the same countries that promoted this at the Council will essentially announce that they're going to promote it at the General Assembly. They'll have an opportunity for proponents to explain what that would mean. One thing I didn't mention that I could have is that this is actually very strongly supported by the UN itself. Earlier this year, the heads of 14 or 15 different UN agencies made a joint statement in favor of recognition, something that had never happened before. And so this would be an opportunity for them to go to New York and make the same kind of pitch that this needs to happen. The way that the Council works, you can have countries sponsor resolutions, co-sponsor resolutions, even if they're not a party, even if they're not a member, I should say, of the Human Rights Council. So even though there are only 47 members of the Council, over 70 countries co-sponsored the resolution. So the General Assembly would start with a lot of countries that are already kind of on board. But still, I'm hopeful that that will happen sooner rather than later. I have to say a big stumbling block there is likely to be the United States. The United States was not a party to the Human Rights Council, not a member, I should say, of the Human Rights Council, but the United States does not feel warmly towards the recognition of a human right to a healthy environment. And so one thing that we're working on is trying to, let's say, let people in Congress know that the Biden administration is taking such a negative position on recognition of the right. For example, senators like Cory Booker and Tammy Duckworth have introduced bills in Congress that are called things like the Environmental Justice for All Act, that some of which actually recognize the human right to a healthy environment. So it's very much contrary to the emphasis by many US politicians, including President Biden, on environmental justice, to simultaneously be opposing the human right to a healthy environment. As I told people in the government, human rights is how the international community talks about environmental justice. So you can't really simultaneously say, hey, we're all about environmental justice, but also be like, but not if we're going to call it a human right. That makes no sense, I think, to anybody really, but it certainly makes no sense in the international sphere.
But that is so confounding. As you've noted, the position of this administration, do you have speculation on what the basis of US opposition is? And I guess in addition to that, once this gets to the General Assembly, the US is a rather large force. Do you think it has the ability to prevent this from being adopted?
No, it definitely doesn't have the ability to prevent it from being adopted, but if it abstained or heavens forfend voted no, then that would give cover to other countries to do the same, I think. And unfortunately, those countries are going to be countries that include Russia and China and countries like that. It's very odd to me that the United States sees its interests, or could see its interests, as lining up more with those countries than with countries like Costa Rica and Germany and the Netherlands and so forth and so I hope that it doesn't come to that. In terms of why they have this position, so we've already mentioned a couple of times that Jennifer and Steve and I go back to, we were all serving in the government together in the early 90s. When I was an attorney advisor in the legal advisor's office, then I actually for a while had the file on human rights and the environment. And I used to joke that it was a very slim file because it only needed room for one page. And you opened it up and it said, "We do not believe in the right to a healthy environment." And you close the file. Nothing has really changed. I mean, the world has just changed in so many ways in the last 30 years, and particularly in the field of human rights and the environment. The Paris Agreement on climate change in 2015 refers explicitly to human rights. I mean, this is not a fringe position by any means. The U.S. position, I feel like that file, if I could go back in the State Department and look at that file, they would not have gotten any bigger. It still has that one sheet of paper in it. I think it's kind of the worst kind of reflexive conservatism in a small c sense. There's no real value to it, I can see. I think some people may be hearing that it would result in some kind of litigation against the United States. That's simply not true. These resolutions aren't legally binding, and no court in the United States is going to base any kind of judgment on a United Nations Human Rights Council or General Assembly resolution. It's going to pass whether or not the United States votes in favor of it. I'm hopeful that this is an example of an issue that just hasn't reached the level of political decision makers that are kind of paying attention. And if and when they do, the U.S. will kind of catch up to the other countries on this.
So unless we then adopted it in our own constitution, our own legislation, the case or Juliana would come out differently because of the U.S. joining it at the UN.
Absolutely not. This is a political commitment. This is a political statement. That's what General Assembly resolutions essentially are. Now, that's not to say it has no normative value. Resolutions can provide kind of rough drafts of later treaties, but more importantly, they can inspire legal change. So certainly, once this is adopted, one of the points is that people will take this and say, hey, we need to meet this standard now. We need to live up to this commitment. But it's that implementation. It's that making the commitment effective that could result in legal change. The political commitment itself doesn't result in legal change. So if the United States concern is we don't even really want to be bothered by this, we don't even really want to give people another ground they can use to criticize us, I just think that's pretty weak tea, isn't it?
Go ahead. And
Hi,
then I see
I'm Richard
three more.
Hiskus. I'm a visitor on campus. I retired from the University of Connecticut. First of all, before we get all pessimistic again because of the United States, this is an extraordinary moment, an extraordinary achievement, this resolution that you are being way too modest about, that you had a huge role in making this happen, Special Rapporteur. So one case you did not talk about is the United States case. And I know that you know it, we've talked about it before. And I've just written about it as an instance of children's activism in the area of environmental rights. So the Juliana versus United States case was just recently decided against the children. And I'd like you to talk about it a little bit because it was at the appeals court level and it lost 2-1, but the dissenting Judge Statton wrote a remarkably brilliant dissent that everyone in this field is convinced will form the basis of a lot more cases, including in the United States. It already has internationally. So what do you think about, it's the United States, so it lost. It was a case suing the United States government for threatening the right to life of children by continuing its reliance on fossil fuels. What do you think?
Yeah, so as you say, Juliana is one of a number of cases brought by children and youth around the world, some of which have been quite successful, kind of spectacularly successful in countries like Colombia and Germany. But Juliana itself wasn't. As you said, it resulted in defeat. As you also said, the plaintiffs were essentially trying to convince the courts to write into the US Constitution a kind of right to a healthy environment. And the courts ended up not being willing to do that. I feel a couple of different things about Juliana. One, I don't think any observers thought there was any real chance this Supreme Court would have let even a strong lower court decision stand that said, hey, there's an implied right to a healthy environment that we just found in the US Constitution. This Supreme Court would overturn that without breaking a sweat. At the same time, as you said, I think it did inspire a lot of attention. It raised a lot of awareness of these issues. It was successful in that sense. And so I expect that it will lead to future litigation, and has already supported future litigation. Whether that litigation is more successful, I mean, frankly, I think in the United States, we would be better off thinking in terms of legislation rather than litigation right now. We need stronger legislation on climate than we have now. It would be great if we could enact something like the Environmental Justice for All Act and strengthen the attention we pay in this country to marginalized communities in a way that they're disproportionately affected by environmental harm. I think we're probably not going to be able to successfully rely on the current judiciary to kind of get there for us without additional legislative help.
So I have several questions in the room, but before I call on anyone, I also want to encourage those of you who are with us on Zoom. I have the Q&A and my laptop right in front of me, and so feel free to put a question in the chat. I mean, not in the chat, in the Q&A, and I'll try and get to all of you as well. Gentleman in the back in the Michigan sweatshirt.
My name is Lauerman. So I had a question regarding the implementation. I mean, I personally believe that the right environment has a lot of other rights. But the problem is that if you keep it too broad, would it have an implementation problem, given that the extensions are from the top powerful states and they're the most biggest polluters?
And before you answer, I'm going to suggest that you paraphrase the question so that people on Zoom can hear what the question was.
Yeah, sure. So if I understood the question right, it's basically like, what about implementation of this right, especially given that several of the largest countries in the world were among the states that abstained, like China, India, Russia, Japan. Yeah, again, I don't think anyone should think of this. I mean, I take Richard's very nice remarks. I mean, I agree with him that this is, I think, a really important moment. At the same time, I don't think anyone should. I think it's dangerous to kind of declare success or something like that. Oh, we have a right to a healthy environment. That's never been true of any other human right. Why should we think it would be true of the human right to a healthy environment? It's simply another tool to use. The tool will be more successful in some countries than others. In some countries, it will be unsuccessful because it's very difficult to use any human rights tools in some countries. With respect to some of the countries that abstain, though, they're in very different situations. And without going into a lot of detail, let me just give you an example. I'm not sure why India abstained, to tell you the truth. India has a very long judicial history of interpreting their constitutional right to life to include a right to a healthy environment. They have environmental so-called green tribunals. They have a very active civil society that litigates in this area. Abstaining on this doesn't change any of that. It doesn't reverse or even slow down, I think, what's already happening in India, or what could happen on the basis of their existing law. So there may be something else going on with them, but I don't think you should necessarily assume that just because they abstain on this, it means that they aren't open to this kind of argument domestically.
Good. Okay. Yes, right there. Wait, sweater.
Hi, my name is Yasmina. Thank you so much for being here. So my question primarily revolves around how do you measure the effectiveness and the success of this implementation in general, and also focusing on lower and middle income countries?
So the question for the folks watching this is, how do you measure the success of implementation of this kind of resolution, especially in low and moderate income countries? That's a really good question. I mean, there are people, there are academics who have been trying to do studies of correlation and causation of rights to healthy environment recognized in their constitutions with various environmental outcomes. It's harder to do that than you might think, or maybe as hard as you would think. So I'm not sure how much weight, frankly, to give a lot of those studies. I think they're useful, but I think we need a lot more data to kind of be able to come up with firm conclusions. I also think in a way, though, it can be a little bit misleading to look at kind of macro measures, as opposed to looking at how particular rights have been used in particular countries in particular cases. In other words, one thing this right gives you, one thing, if it's recognized in your own country's law and constitution, and again, you have courts that are willing to hear the cases, it gives you access to forums that you don't otherwise have. And once you have access to that forum, you're able to make arguments that can have unpredictably awesome effects. The agenda case I mentioned that was just decided in December of 2019, I had Dutch lawyers telling me, very well-respected Dutch lawyers telling me 2 years earlier, after the lower court had issued the first decision in favor of the plaintiffs in that case, there is zero chance this case is going to stand. This, on appeal, they're going to lose. After the appellate court decided in favor of it, they said, no, the Supreme Court's going to straighten it out. So you don't know where you might be able to go with these kinds of legal tools. But the point is, again, to go back to the previous answer, if you don't have the tool at all, then you can't use it. Once you have the tool, then you can start trying to see what you can get with it. And in some cases, you're going to be successful.
Thank you.
Great. What in the back?
Hi, I'm Lauren. Related to this question and answer that you just gave, do you think negative outcomes in national courts or in treaty like international bodies set the right back? Like, it had the Netherlands case gone differently, or thinking about the US case that did not come out in favor of the children, like, does that set your issue back at all?
I mean, I think actually it can set it back in a particular jurisdiction. I don't think it sets it back overall, but certainly if you bring a case that is, let's say, not very sympathetic or is poorly argued, and so you lose, then that does create a precedent that then within that jurisdiction, later litigants are going to have to try and overcome or work around, which makes it really important to make sure that the first cases brought, the ones that set the first precedents, are in fact as strong as possible and are argued as clearly and successfully as possible. At an international level, one of the things I was told actually when I first got this mandate, well, to tell you a story. After I got this mandate in 2012, I had I had lots of calls with different people who wanted to tell me what the mandate should be doing, and I wanted to hear from them what they thought the mandate should be doing. Two of the first calls I got, one was from somebody who said, well, the first thing you should do is declare that there's a human right to a healthy environment. I was like, oh, really? Almost the same day, certainly the same week, I had another call with somebody who said, well, whatever you do not declare there's a human right to a healthy environment. And I was told by a more senior academic in this area, someone who worked in this area a really long time, she said, you know, this came up in the Human Rights Commission in the early 1990s and went down to defeat. I have some slides on that, which I didn't bother to show you. And that kind of killed it in the UN for over 15 years. You can't screw this up. Like, if you bring it up prematurely and it gets voted down, we can't really lose another 15 or 20 years on this until the slate is clean enough to bring it up again. So I took a very methodical step-by-step approach. I wanted to build a framework so that by the time we brought the right to a healthy environment for formal recognition, states wouldn't be able to say, well, what does this even mean? This isn't really studied enough, we need more time. I wanted to have all of that groundwork laid. And I basically took 6 years to do it. So going back to what Jennifer said, that this is kind of moving at lightning speed. At the UN, 6 years kind of is pretty fast. But this meant that when I handed things over to David, who had literally written a book on recognition of the human right to a healthy environment, David was able to take that baton and immediately start pressing for recognition because the framework was built up. Even then, it's taken 3 more years to get to where we are today. And again, we took it step by step precisely because we wanted to avoid a negative outcome. We felt like we just felt like it's better to wait an extra couple of years than to go prematurely and screw this up.
Shut down twice would be hard to come back.
It'd be really hard. It'd be difficult. We'd be creating
Definitely. Yes, in the blues, yes.
Hi, Garita Badun. I'm a visiting professor at the law school. Thank you for this wonderful talk and all your work in this area. And at the risk of asking you to give another talk, I was wondering if you could give us your assessment of the outcome of COP26. I follow you on Twitter, so I know some of what you think about this, but I haven't seen what you've posted since the final document. And I'm wondering if you think that future COPs, like in Egypt next year, the fact that this is now sort of sanctified as a human right, that this will have an impact on the ongoing negotiations. And if I can sneak in one more question, I heard that Greta Thunberg wants to now bring some sort of legal action to get the UN to declare a climate emergency or an emergency situation. I'm wondering if this human right will help her in that process and her allies. Thanks.
So first, Karima, you say at the risk of, don't you, at the risk of getting me to give another talk, aren't you, wouldn't that be a positive?
It would be
Don't you
very
want me to?
positive.
I mean, it's like you don't want me to do that. I have all other slides
I do.
ready to go. I hope you aren't got any other plans this evening. For those who don't know, Karima just finished her own 6-year term as the special rapporteur on cultural rights. She's just done an amazing job in that. It is now should be enjoying a well-earned rest, but knowing Karima, she is not. She is going to go on to other things and achieve lots more things. You know, it's difficult to kind of sum up COP26, except I didn't have very high expectations for it, so I'm not disappointed. If I had higher expectations, then I would be disappointed. I think no one should have high expectations about these COPs. They're essentially political dog and pony shows, and the real work that's happening is not being done at the COPs. So does that mean they're totally meaningless? No, but it means that you should take them into account. You should put them in the context of all of the other things that are going on in the world to try and get a grip on climate change. The COPs again are kind of more like they're more the effect of all those other things. They're more the sign of what those other things are doing than they are actually driving change themselves. In terms of Greta Thunberg asking the UN to declare a climate emergency, David and I have supported that. The idea would be that the UN Secretary General would basically say, as he has said, as Secretaries General have said in some other contexts, this is such an emergency that justifies my putting additional resources into this and having this be a higher priority for the UN as a whole. Would this actually change what governments do? I have my doubts about that, honestly. But it would certainly continue to raise awareness of it and continue to keep it high on the agenda, and those are valuable things. In that context, the right to a healthy environment, I think, is useful. But again, I think it's just a tool to use along with a lot of other things.
Just to amplify a little bit what John said about the COP, when you think about the fact that it's an institution of almost 200 countries that never managed to agree upon decision-making rules, and so the decisions all have to be made by consensus, it's not surprising that that body is incremental. It's very slow-moving, and it basically represents, you might say, the lowest common denominator amongst all those countries. In which case, some of what came out of it is pretty impressive, that they did actually call out coal, not very strongly, but they did. So. But let's go back to human rights. We have lots of questions. I would like to go to one on the Zoom from one of our virtual visitors. This goes back to the question about India, and that is, to what extent do you think an increase in authoritarianism and the rise of the far right, the BJP in India, has affected their environmental initiatives? Would that be a reason they abstained, that the politics have shifted in the country?
I just don't know enough about India to really be able to answer that question. But I will say generally, the rise of authoritarianism around the world, I think, is very much associated with environmental degradation. This is in some ways the core lesson about the relationship between human rights and the environment. The willingness, the ability to make real progress on environmental issues depends on a civil society that's given the rights to participate, to find out information about environmental harm, to seek redress, and so forth. If you don't have those things, then you tend to have higher levels of environmental degradation, but also in particular, levels of environmental degradation that disproportionately affect the most marginalized and discriminated against people in the country. So that's my general answer. But in terms of Indian politics, I just don't want to speculate because I don't feel like I know it well enough.
Okay, Red Hat.
Hi, I'm Samina. Can you talk about the perception and potential impact that this right might have on some of the multilateral development banks that are ideally are going to be funding ideally sustainable development. And I mean, some projects, the environmental benefits are pretty clear, like, turning off coal plants, turning on wind and solar. But for things like hydroelectric projects where both the pros and the con side are both making appeals to the environment?
Yeah, that's a really, really good question. One of the things I was disappointed about in the COP was that the rules for climate finance do not clearly include protections against just the types of human rights abuses you're talking about. So for example, when I was still a special rapporteur, one of the countries I went to was Mexico. And I heard there from people who were describing, indigenous peoples who were describing how their land was being taken for solar farms. If your land's being taken away, if your ancestral territory is being taken away, it doesn't really matter a whole lot why it's being taken. If it's been taken for mining or solar farms, you're still having your culture destroyed. It's not too surprising that the renewable energy projects, especially the big massive ones like hydro, big solar farms and wind farms, countries tend to put them in places where the populations are most marginalized, the communities are least able to fight back. And that's very much contrary to what a human rights approach would say. It's not that you shouldn't have solar farms, but that you shouldn't put all the costs on the people who, after all, are contributing least to the problem to begin with. So yes, one of the things I hope will happen with this recognition of a right to a healthy environment is that multilateral development banks and other international financial institutions that are going to be pouring billions of dollars into climate projects, but also biodiversity conservation and other types of projects, that they do understand that they have to take into account the human rights consequences of these actions. As I often would say, you don't check your human rights at the door just because you're pursuing a project for sustainable development or to have more renewable energy or anything like that. You can't get there by human rights abuses. You have to get there the right way. It's also worth pointing out that usually that means the project is more effective from an environmental or conservation basis as well. Usually the projects that most oppress the human rights of people turn out to be projects that don't pay off environmentally either. Those projects are often tend to be more corrupt or more riddled with corruption, less effective because they have been less vetted by the people who are most effective.
Yes, thank you. I'm Robert. Thank you. I think with a lot of the focus has been on sort of the shortfalls of enforcement. This is the domestic level and internationally with countries that maybe don't have this written in their own constitutions. But I'm wondering what are some of the mechanisms for enforcement at the international level? Maybe this gets into the overlap with climate change you were talking about. Versus a lot of this is actually nation on nation sort of harm and deprivation of that lack, and maybe it gets into what you were talking about. Safeness dropped out of the final thing, but with low-lying nations and things like that. What this says for enforcement at that sort of international level, they're akin to other human rights that have been violated across national lines.
Yeah, that's a really good question. And I'll just repeat it in case people didn't hear it. I'll just summarize it. Tell me if you think my summary is leaving something out. But the question is basically, so what's the effect of all this kind of in terms of international enforcement with respect to, for example, low-lying states that are severely affected by climate change? Will this, for example, help them bring actions against major emitters? I do think this may be part of what the United States is concerned about, frankly, is that this will contribute to arguments like that. You may have read about kind of an on-again, off-again effort to get an advisory opinion, to get the General Assembly to request the International Court of Justice for an advisory opinion on the effects of climate change. Clearly, if that ever happened, and I think it's getting more likely, if and when that happens, you would expect that one of the sources of law in that respect would be human rights. That would be an obvious thing for the International Court of Justice to be asked to focus on. So in that sense, the clearer the human rights gets in this area, the stronger those kinds of arguments can become. But in terms of what we think of as like more traditional litigation, let's say Tuvalu suing the United States and China, there's just lots and lots of barriers to that at the international level, so many that it's very hard for me to see how that would ever really happen. I think it's more likely that this will, again, perhaps inform an advisory opinion, but in particular, what I think it will do is inform and support arguments in for example, in the context of loss and damage arguments, in which the most vulnerable countries in the world are essentially arguing that the major emitters should be paying for the loss and damage that climate change has caused. Again, putting that in human rights terms, I think, does strengthen those kinds of arguments.
But is the loss and damage is sort of paying for harm already caused. So that's almost sort of a looking backwards. But I suppose going forward, that might be another reason the United States is concerned, right?
I think so. Yeah, that's right. That's right. Because the damage is in the past, but it's also very much continuing and expected to get worse. And so
More actions in the past, it will
Yeah.
continue going forward. So that could be part of their.
I think there's a good chance of that. Yeah. But again, you can make those arguments in that. I mean, it's not like the idea that an additional UN resolution is going to provide the tipping point that somehow going to make those arguments. Again, these are political arguments. The United States is perfectly prepared and has in fact said, well, you can make all the arguments you want. We're not writing you big checks because we think you owe you. We will provide support, but not in a kind of liability sense.
For resilience, for adaptation,
Yeah.
not for reparations.
Right, exactly.
Another question from the virtual audience, Lauren Nishimura. In general, cooperative duties that can be derived from human rights law are often contested by developed countries. I'm thinking of ICESCR Article 2.1. Do you think a right to a healthy environment can strengthen extraterritorial obligations to assist and cooperate in global environmental issues? And if so, how?
Yeah, so the question here has to do with what's sometimes called extraterritorial obligations or duty of cooperation to deal with issues that cross borders or certainly like climate change involve the entire global community. And as the questioner correctly points out, developed countries have often resisted the idea that under the International Covenant on Economic, Social, and Cultural Rights, for example, they owe any true extraterritorial obligations, whereas developing countries are more likely to say, you do owe us obligations when you're causing harm in our areas, in our territory. Yes, absolutely. Actually, the intersection of climate change in particular, but environmental harm more generally, and extraterritorial obligations is already turning out to be, let's say, a fertile area for decision. I mentioned the Committee on the Rights of the Child case that was just decided last month. The committee, again, decided against Greta Thunberg and her co-plaintiffs, but it decided against them on the ground of non-exhaustion of local remedies. It basically said, you have to go to local courts in these countries and see what you can get first, and then come to us if that doesn't work. They didn't have to say what else they said, but they went out of their way to also say, having said that, we think we do have jurisdiction to hear a claim essentially complaining about the extraterritorial effects of climate change on people living in different countries. So I expect to see more cases like that moving forward.
Yeah, a short one and then maybe a longer one. The short one is UPR, Universal Periodic Review, going to incorporate this new right as part of the sort of checklist when starting with the next UPR or a review? And then the second question is, on the one hand, how do you thread the needle between reassuring the United States that this can't be used against them and telling everybody else about how this could be a tool for litigation and legal triumphs? I mean, this sort of played itself out a long time ago with how do you convince US to ratify the ICCPR? And so, because every argument you're giving outside the United States about the power of this new GA resolution is an argument that would be used against you by domestic opponents of it.
Right, let me take that one first. So you're absolutely right. There's kind of on the one hand, you want to be like, yes, this really matters. But on the other hand, you want to be like, well, it's not going to matter that much. And so those two arguments do kind of tend to be in tension with each other. The thing is, I just think it's accurate. I mean, it's simply the fact that this does give you a tool. As I tried to say earlier, it's a tool that could lead to legal change. It's not the legal change itself. How useful that tool will be in different contexts depends completely on a host of other factors that are each unique to every single country in the world. In the United States in particular, because of things like the fact that the US court system absolutely will not take into account Human Rights Council or General Assembly resolutions in deciding anything, because of the fact that the United States government is not going to suddenly change its mind about loss and damage if a General Assembly resolution is adopted, it's fair to say you could vote for this and not have this parade of horribles that you're apparently telling political appointees in the United States that would happen. That's simply false. If you're telling it, the lawyers in the United States government are telling political appointees that we can't vote for this because this will result in legal claims that we then won't have as good a defense against, that is a falsehood. Either they're being bad lawyers or they're just misinformed. But that's not to say that it won't have any effect at all. It certainly will contribute to political arguments. I just happen to think those are political arguments the United States should be prepared to combat on their merits. In terms of the UPR, I hope that it's going to be added to the UPR. I mean, I think this is part of the justification for getting it adopted at the Human Rights Council. It would certainly seem strange to me now for it not to be included in the UPR. Remember, the Universal Periodic Review is not linked to any particular treaty. It covers the whole field of human rights with respect to all of the parties to the United Nations. For the United Nations to say, hey, here's a resolution recognizing a quote unquote new human right and then not include in the UPR would seem strange to me. So
Did they do that after UNDRIP was adopted? Did they start including Indigenous people's rights in UPR? Or well, UPR was maybe hadn't been created yet, but
yeah, that
I'm
created yet. I don't know
might be
the
a
answer to that. I know for rights to water and sanitation, though, that they're definitely included now. And I think that would be the kind of the specific reference. Yeah.
Do you think that the language in this declaration is going to come up during or at the case that Indigenous activists in Brazil are bringing against Bolsonaro for crimes against humanity and other environmental crimes?
So yeah, it's interesting you asked. So the question here is, for people who didn't hear this, so there's a reference to the International Criminal Court brought by people on behalf of Indigenous peoples in Brazil against the Bolsonaro government. And the argument is essentially that the actions of the government amount to crimes against humanity and therefore within the jurisdiction of the International Criminal Court. The International Criminal Court said 4 years ago now that it would consider certain types of massive environmental harm as eligible to be considered as crimes against humanity. Everyone expected the case that they had in mind there to be a case involving land grabbing in Cambodia, but for reasons I've never been clear about, that case has never gone forward. So this is an opportunity for the International Criminal Court to go forward on this. I know that I mean, I've been in touch with the lawyers who have made the reference. I think they think of it as a positive thing that helps kind of make their case. But again, their case is very specific. It's got to be tied to crimes against humanity. And so if we had more time and I was clear in my own mind about this, I would try and kind of trace out exactly how they think that this would help them make that case. But that's the main thing to keep in mind. It's got to be tied to crimes against humanity. Otherwise, the International Criminal Court, doesn't have jurisdiction to hear the case.
Anything else we haven't called on yet?
Maybe it's because I'm a political scientist, John, but I think that you can't rule out the power of the political moment in situations like this. The United States is the only country that's never ratified the Convention on the Rights of the Child. When we were putting children in cages, I wrote the Trump administration and said, you know what you guys should do right now? Have the Senate ratify the Convention on the Rights of the Child. Ronald Reagan did exactly that about the Genocide Convention. When we were the only country who hadn't signed it, he got in trouble in a public relations snafu, laying a wreath in a German cemetery that included some SS officers. Said, what can I do to win the moment? And they ratified the Genocide Convention. If the Trump administration had any intelligence, they should have done the same thing there. I think that those kind of moments are possible. And the Biden administration is much more savvy than the Trump administration on this score. And subsequent administrations might be too. It might take a while, but you're right that it always is about political will. But there are times when those moments just happen and a huge step is taken.
Well, Richard, your lips to God's ears. All I can say about that. I mean, I'm certainly.
I'm an optimistic political
I
scientist.
don't want to argue with you about that. I really hope that you're not going to be right.
I think I just heard him say Biden should put children in cages.
No.
Fabulous. Other questions? Yeah, we're going back here.
Yeah, so I'm sorry for asking another, but it's regarding the language. I mean, I saw in the first draft there were these words mentioned, mental and physical health, but in the next one it was just a healthy environment. And I've had an observation that, like, did it mean that you wanted to take out other rights, such as, you know, I believe that a healthy environment is where you have your culture as well, like it's there. So, more like, you know, so is it still there or is it like out?
So again, the question here is basically about the language in the resolution itself and the absence of, the first draft had a clearer connection between the right and other human rights, and that got watered down in the later drafts. I think that was really unfortunate because I think it was really useful language to make explicit the relationship between this right and other rights. And some countries were so upset by that that they actually went from strong supporters of the resolution to, let's say, more lukewarm supporters of the resolution afterwards. However, as a legal or normative matter, I think those connections are there, whether or not the resolution spells them out or not. And they're there because of the last 20 years of decisions by all of these national, regional, and international bodies that have made those connections. So although it would have been nice to be more explicit about that, I think it's still very much a fruitful area of analysis and further discussion. To give you, if you're interested in this, to point you in one particularly interesting decision in that respect, an advisory opinion by the Inter-American Court of Human Rights that came out in 2017 is this kind of overarching view of the entire field of human rights and the environment. One of the things they do is try to do this tying together of the right to a healthy environment with other human rights that are separately protected. And I think that's a very, again, valuable kind of stitching together. I would have liked, I mean, again, as you know, as I said, I would have liked the resolution that the council adopted to include that. Maybe the General Assembly resolution will be a little bit more explicit about that. We can hope.
I think we have time for maybe one or two more questions and then we'll wrap up.
So a few of us are from the School of Public Health, at least I know we are. I don't know if anybody else is, but we really do study the importance of the environment when it comes to population health, as you know already. And so my question basically is, how much does the UN rely on the WHO for information when making decisions like this? Because it seems like the WHO really places an importance on the environment and population health.
Yeah, that's a really good question. So I don't know how involved the WHO was in this resolution in particular, but for example, when my successor, David Boyd, who, by the way, doesn't introduce himself as the successor of John Knox, so that's not a part of his name or anything, but David did an important report on air pollution and human rights. It was one of the first reports he did. And the WHO is extremely involved in that. The WHO is very much on board with the idea that a rights-based approach to human health is a useful way of thinking about it. And so, you know, so they embrace this kind of synergy, I think, between human rights and their work. So, and in fact, I would say that's true of lots of different organizations within their own areas. The Environment Program has very much strengthened its attention to rights-based approaches to environmental protection. And so I expect that kind of thing to grow and build in the future as well. As I said, one of the remarkable things about this was that 14 or 15 UN agencies split their leaders, their directors came out in favor of this. I think WHO is one of them.
All right, well, thank you all. I think, John, this is your moment. If you have any wrap-up final messages or things that you skipped in your opening presentation, you want to make sure to leave us with.
No, I think all I'll say is that this to me is something to be optimistic about. Like you asked me, Karina asked me about COP26, that doesn't leave me super optimistic. What makes me optimistic is that I read almost every week, it seems like, about a new case that's being filed or decided somewhere in the world that's a rights-based approach to climate change or other environmental protection. This empowers people to seek positive environmental change, and they are actually doing it. It doesn't get as much attention as a bunch of political leaders coming together and issuing declarations. But this is actually what's driving a lot of the positive change we see in the world right now. That doesn't mean it's a sure thing or that it's all up, it's all downhill. And I forget which way downhill is good or bad. Anyways, it's not always positive, but there's a lot of positive things going on right now. There's a lot of really admirable work going on right now in this field. So I think that's something to be excited about.
That's a great note to end on. Excitement, optimism. Also, thanks to the Donia Center for bringing you and for giving us all this chance to have this great conversation. I hand it back now to our director, Steve. Nope, we're done.
Thanks.
All right.